Before we begin, Major Miller is going to make a quick, announcement.
Very quick, I promise.
Good afternoon. On behalf of Justice Stratton, Chief Justice O'Connor, and the Ohio State Bar Association's new Military and Veterans Affairs Committee, I'd like to welcome you to our event this afternoon and encourage anybody, legal practitioner, law student, spouse, to consider joining our committee. It's a very important new initiative of the State Bar. Justice Moyer really started it with Justice Stratton, and we've already been able to work with the Attorney General's office to stand up a legal assistance service for all military members regardless of income. I'm very proud of that and what our committee is doing, but we need you to make our committee the committee that it can be. Thank you very much.
All right. General and distinguished speakers, you may be seated. Ladies and gentlemen, it's really wonderful to look out and see such interest in the issue that we're going to be speaking about today. I'm Professor Michael Scharf, the director of the Frederick K. Cox International Law Center, and together with Bob Strassfeld, who will be chairing this panel today, who is the director of our Institute for Global Security Law and Policy, we're very happy to be the co-sponsors of this event. We also are very fortunate to have been given a generous grant from the Federal District Court for Northeast Ohio to support this. In organizing this event, I want to do a shout out for Brett O'Brien, who helped me come up with this idea and invite and secure the speakers. This is Brett.
Great job.
Thank you. And before turning it over to Bob to start the panel, I do want to give some thank you gifts for the speakers who have come from their busy jobs in the city and in the case of General Beck from far away. General, this is for you. And for the rest of you, we'll just pass those down. These are Cox Center fleeces. You become a walking billboard for our program. We have been changed as an academy, as an institution from 9/11, just like the world has been changed. And it is our mission to explore the most important and difficult legal issues of our generation, of our times. And I just want to let you know of some of the symposium issues that resulted from conferences and that were published in our journal over the last 9 years since we started having panels after 9/11. In 2004, we had one called Terrorism on Trial. In 2005, Rebuilding Nation Building. In 2006, right when the White House torture memos had just been released, we had a conference called Torture and the War on Terror. Then, in 2007, right after the Saddam Hussein trial, we had one called Lessons from the Saddam Trial. In 2008, Sacred Violence, Religion, and Terror. 2009, security detention. Now we're starting to focus a little bit on what's going on in Guantanamo. We had one in 2009 also, combating terrorist financing, and 2009, after Guantanamo. We optimistically thought they were going to be closing down Guantanamo. This probably should be renamed Continuing Guantanamo. And then finally, last fall, we had a conference on lawfare, and just last Friday, our conference was on international law in crisis. These are issues that you all will be talking about, looking back at 9/11 10 years later, which we've been wrestling with here, and we are very, very pleased that you all came here today to have what's going to be a capstone discussion of those issues. And I now turn it over to my colleague and friend, Bob Strassfeld.
Thank you, and thank you for coming. I guess two comments apropos Michael's, and then I will get out of the way rather quickly and introduce the panel. First, with regard to symposia, I will take the opportunity to do a shameless plug of a symposium that the Institute for Global Security, Law, and Policy will be holding on Friday, September 23rd. The title of the symposium is Universities and National Security After 9/11. And I hope that many of you will be back here for that. Information about the symposium is on the law school website. Michael said something about a capstone. I think that may be optimistic. There has been a lot of discussion, obviously, of 9/11. This weekend, I heard somebody talking on the radio who was asked about lessons and what we have learned and whether we have turned some sort of corner. And he reminded the questioner that when Zhou Enlai was asked about the impact of the French Revolution, he said, "I don't know yet, it's too soon to tell." I think capstone is somewhere in the distant future. Indeed, we've been marking a 10th anniversary, and 10 is very arbitrary. I mean, there's something sort of odd about designating 10th year, 20th year. Those of us who do history know that history doesn't happen in neat decades. All the same, when I saw Michael's pile of literature, and this is produced from one university, I promise you that many others have similarly, diligently been destroying the forests of the Northwest. It does seem clear that it is time to take stock and to begin to think about lessons learned, what we can say about the experience, both 10 years after, but 10 years after suggests that 9/11 is a moment in time and then everything goes on. In fact, we have been in a continuous state of war since 9/11. What's the impact of being a nation at war? A strange kind of war, to be sure, where most of us are attenuated from the day-to-day events of war. So, we have assembled these wonderful people from a variety of disciplines and professions, a variety of viewpoints, to reflect on where are we now, what have we learned, what do we need to learn, and many other things which they will choose to talk about. For those of you who have the booklet, you have bios of our speakers. I don't want to spend a long time introducing them, but I do feel like I should give them their due and highlight some of why they are here today. Immediately to my right is Brigadier General Gill P. Beck. He is currently the commander of the U.S. Army Reserve Legal Command. He was previously Chief Judge of the U.S. Army Court of Criminal Appeals. He served as an Associate Deputy General Counsel in the Office of General Counsel in the Office of the Secretary of Defense at the Pentagon, where he was responsible for Iraq and Afghanistan legal actions. He was also the executive officer in 2008 for the Army General Counsel. The Iraq and Afghanistan desk followed from his service as Staff Judge Advocate of Task Force 134, which dealt with detainee operations in Baghdad, where he led a joint services legal office in the prosecution of terrorists and assisted the government of Iraq in the establishment of the rule of law. To his immediate right is my new colleague, Avidan Kaver, who comes to us from Seton Hall Law School, where he was visiting assistant clinical professor. More relevantly to the discussion today, from 2004 to 2007, he worked at Human Rights First as a senior associate and senior counsel in the Law and Security program, where he litigated and wrote about many of the issues that we'll be discussing today. In addition, he served as Assistant Corporation Counsel for the New York City Law Department World Trade Center Unit, litigating numerous claims regarding municipal liability arising out of the 9/11 attacks. To his right is also my new colleague, Professor Shannon French. She is the director of the Inamori International Center for Ethics and Excellence here at Case Western. She is also a tenured member of the philosophy department, and my new colleague because she now has a secondary appointment at the law school as well. Prior to our luring her to Case Western, she served on the faculty of the U.S. Naval Academy and was the associate chair of the Department of Leadership, Ethics, and Law. She is a specialist in military ethics. In 2003, she published the book, The Code of the Warrior, Exploring Warrior Values Past and Present. To her right is Dennis Terez, who is the federal public defender for the Northern District of Ohio. He has been since 2006, and it is, I gather, about that time that the Federal Public Defender's Office was appointed to represent detainees in, shortly thereafter. How many cases have?
Roughly 9.
Represent roughly 9, that's interesting. Guantanamo detainees in habeas litigation. And we decided to put prosecutor and defender next to each other. To his right is Justin Herdman. He is an assistant U.S. attorney in the Northern District of Ohio. He also teaches counterterrorism law here, but he is the, at the U.S. Attorney's Office, he is the Deputy Chief of the National Security, Human Rights, and Organized Crime Unit. The bio lists 3 terrorism cases that you have prosecuted. Have you done more, and those are
I've prosecuted,
just the best of?
Prosecuted 3.
Okay. Here in the Northern District of Ohio, he is also a judge advocate in the U.S. Air Force Reserve and a former Navy intelligence officer. And with that, I will get out of the way and let them speak. I should say, with regard to the federal employees, the usual disclaimer that they speak for themselves and not the federal government applies. They can no longer get in trouble for what they say, because this is being webcast. General?
Thank you very much. I come from far away, Greensboro, North Carolina, so I will carry back to Greensboro this bag, and it is truly an honor to be here. Every opportunity, someone has pressed upon me that all of the great things that Case is doing, one of the first 8 law schools in the country, the 15th best international law school, tied with program, tied with Stanford, and moving up soon to leave Stanford in the dust. But what a pleasure to be here. What a pleasure to be here. And to have the opportunity to address the issues that are so important to our nation. To look back after 10 years and to learn, to think about what we have learned, but also to think about what we should be thinking about in the future. The background I bring is one on twofold. One, as a judge advocate in the Army Reserve with over 33 years experience, specifically experience from Iraq, working with detainee operations, working with the Iraqi government, building judicial capacity in the Central Criminal Court of Iraq, helping commanders, helping the United States leaders in Iraq comply with the law. And one of the things that you'll see as I talk is that the commitment of our military, the commitment of our government to compliance with the law. We have learned a lot over the past 10 years, but our learning is not over. We still have much to learn and much to apply to be ready going forward. Also working in the Office of the General Counsel in the Department of Defense, had an opportunity to work very closely with other federal agencies, the Department of State, the Department of Treasury, other federal agencies, and learned the value of the interagency process and how we benefit and how we are better as a federal government when we approach problems through the interagency process in a very unified, synchronized manner. Also, I'm an assistant United States attorney, having served for 19 years in the Middle District of North Carolina, and my disclaimer is doubly, both on the part of the Army, which I'm today here on Army Reserve duty, and on the part of the Department of Justice. These are my views, but it is indeed an honor to be here. Let me start off with yesterday. Yesterday, I had the privilege of being in Albany, where there was a 9/11 memorial. At that memorial, there was recognition to a Lieutenant Colonel Bill Paulman, Army Reserve. He was assigned to the 4th Legal Support Organization in the Bronx. On 9/11, he was in the South Tower, approximately the 79th floor. Yesterday, Colonel Pullman died, but yesterday his wife and his 2 sons were there. And Mrs. Pullman, to bring home just how close this particular matter is and how raw the emotions still are even now, 10 years after, she recounted that 10 years before, she spoke with her husband sometime after 8:46 on September 11th. The North Tower was hit on 8:46, but her husband called her. His immediate response was to call and let his wife know that he was okay. At that very moment, his son, who worked on Wall Street, also called. He responded to his son and told his son that he was okay. He called back a few moments later, and when he did, he and his wife had a very brief conversation, and then the second tower was hit. And then that was the last that Miss Pullman talked with her husband. At that particular point, this is one family. At that particular point, Chris, as I described, was coming over from Wall Street. His son, Darren, happened to be in Washington, D.C., and shortly after 10 o'clock, after the plane had crashed into the Pentagon, Darren called his brother to see how his father was and reported that the Pentagon had been attacked. And Chris, who was walking or running probably over from Wall Street at that point, knowing that both towers had been struck and the Pentagon had been struck, his response was he thought that the gates of hell had opened. He thought that at that particular time that the worst imaginable thing that could happen to our country had happened. He also said that for him, as he came over from Wall Street trying to get over to the Twin Towers, to see if there was anything he could do. There was nothing he could do for his father, but to see if there was anything that he could do. He said the hardest thing was to look back at ground zero and to see the smoke and to know that your dad was there and there was nothing he could do about it. And that, for that family, is as present as it happened yesterday. So 10 years after the fact, that is the experience that this family is dealing with. Now, one of the things our nation has learned in the event of, in terms of combat, and I lead an organization of 1,700 judge advocates and paralegals all over the country, is we've learned about post-traumatic stress disorder, the negative things that happen after combat. There's also post-traumatic stress growth. That's not a medical term, but in terms of what we have also seen in the past 10 years is the ability to grow. And I would relate to this particular symposium that in our legal world, there is also the opportunity to grow, to learn, to do better for the future, and we owe it to our country to do that. I read where the President said in an op-ed, like any American, I'll never forget how I heard the terrible news. And that brings back to almost everybody, I would say everyone in this room, you remember very vividly 10 years ago what exactly was going on when you heard about the attack on America. And he also said that one of the challenges that he has and any parent would have in terms of what do you tell your children. And so his daughters, Malia was 3 and an infant, and Sasha was an infant at that time, but they've grown up. But what do you tell them? And he said, and I thought it was very, very appropriately, that out of the worst terrorist attack in American history, also the best has come out of our country. And that would be what I would hope that we have learned over the past 10 years. That not only that terrible things can happen, but that it can inspire us to do things that are even better as we go forward, so that we're better able in the future, that we can do something in the future to prevent these kind of things from happening. I saw the 9/11 Commission documentary, and they talked about bin Laden had been sighted in '99, and there were various efforts that were directed at possibly taking action to take out bin Laden, and for a variety of reasons, through no one's fault, it didn't happen. But what a different world we would have today if we had been successful in 1999 taking out bin Laden. What a different world we would have than we do now. Our challenge for the future is to be better prepared as we go forward to protect our civil liberties, to protect all those things that make us what we are, Americans, and what I am so proud to be part of, our American government, our American history, but at the same time to make sure that we never let this happen again. In terms of our military, one of the lessons that we have learned is the absolute essential role of the law and of legal advisors, the incredible role that attorneys play in ensuring compliance with the law. In Iraq, in Afghanistan, throughout the world, our commanders are working hand in hand with legal advisors who are highly skilled, highly trained, some of the very best people that we have. In Afghanistan now, the advisor with regard to detainee operations and rule of law operations is a brigadier general within the Army JAG Corps, Mark Martins, a Rhodes Scholar, Harvard Law Review. That is an example, but not the only example, of the kind of talent that we are applying to make sure that we have our very best legal professionals in a position where they can ensure compliance with the law, but they can also help those commanders deal with difficult and tough and challenging issues and come up with answers that allow us to meet the challenges our nation has. General Terez, who recently retired, said military lawyers were combat multipliers. In essence, we threw lawyers at very difficult problems, and they produced, in virtually every instance, outstanding results. I tried to get all the lawyers we could get and then sought even more. That is one of the lessons we've learned since 9/11, the important role that the law plays and the important role that judge advocates play as we go forward in helping commanders comply with the law, in helping us meet all of our international obligations, in helping us generate options in accordance with the law that allow our government to go forward. Another example of what we have learned as we have gone forward is the importance of the interagency. One of the very important lessons we learned in the 1980s was that we cannot function as a military where we have stovepipe organizations, where the Army is not communicating with the Navy, it's not communicating with the Air Force. So the 1984 Goldwater-Nichols Act was enacted, and that basically started creating a culture, but also a legal framework that required organizations to work together. As a result of that, we became better within the military because we became better at operating in a joint environment. That allowed us to do so many things so much better as we go forward. No longer were we limited to particular stovepipes. We were sharing information, working together on a habitual relationship. One of the lessons we have learned since 9/11 is that in our federal interagency, we must do the same. We cannot live in stovepipes. The 9/11 Commission report and other reports have indicated the problems in terms of intelligence when you have one agency with information not sharing it with another agency. There have been tremendous efforts to break down those walls, to share information, to make the interagency process more responsive, to make it more effective, so that the Department of Justice can work even closer with the Department of State and with the Department of Treasury, with all of the federal agencies, so that when we come at a problem such as terrorism, we come at it with an integrated, synchronized approach that allows us to put the full force of our federal government at the issue of counterterrorism as we go forward. Finally, the lesson that I draw from the past 10 years is that we've got to be prepared. No one would have anticipated 9/11, or if they could, why didn't they tell us? And we've got to be nimble. So the first inklings of information that the FBI was getting, we've got to be able to take that information, and we've got to be able to respond quickly. But we have to be prepared. We live in a world where it remains a dangerous world. We live in a world where we do have enemies. We live in a world where there are weapons of mass destruction. And if you talk and look at the various documents that our military leaders, they describe the threats. The idea of a nuclear explosion in one of our cities is one of those threats that we've got to do everything we can to be prepared, to make sure we're using the full force of our interagency so that we never forget what happened on 9/11, and we remain ever vigilant in terms of being able to go forward and defend our country and respond with the federal government in an integrated, synchronized manner going forward. I think I will have a chance to answer questions at the end, but I will have to leave early to catch a plane. So if you see me leaving a little bit early, it's not going to be out of disrespect for the comments of the other speaker, but it is going to be just the reality of getting back to the office. So with that, it is indeed a pleasure to be here. I am so impressed with Case Western and Cleveland. What a fantastic place, and thank you for the honor of being able to speak with you. Thank you.
Hi, I'd just like to thank everyone for putting together this wonderful panel. I'm quite pleased to be a part of it. I'd like to very briefly sketch out the current state of detention operations that the United States is running and directing across the world. And in so doing, I'd like to then ask, how did we get here? What are the purported reasons and policies and legal analyses that supported this detention state? And then ask, and hopefully answer, why are we still here? There's been a change in administration. Why does this detention state across the world persist? Is this a vindication of the Bush administration's policies? Or is there some kind of distinction that we can find? First off, right now the most famous detention center is Guantanamo Bay, the U.S. naval base at Cuba. There are about 170 detainees held there. At its peak, there were almost 800 detainees held there. No new prisoners have been transferred there since 2007. About 90 of these 170 detainees have been cleared for release or transfer, but due to fears of recidivism and congressional restrictions, none of those individuals have been released. Of the other remaining 80 detainees, about 30 are currently facing or are expected to face military commission trial, and another 50 are to be held indefinitely without trial. Now, what of judicial review? The U.S. Supreme Court has handed down 2 decisions regarding Guantanamo Bay, in 2004, Rasul, and in 2008, Boumediene. What sort of judicial review now is there? Boumediene explained that the right of habeas corpus protected by the suspension clause must include the power to formulate and issue appropriate orders for relief, including, if necessary, directing a prisoner's release. Yet the D.C. Circuit has time and again quashed orders by district judges granting habeas petitions. Indeed, in only one instance has the D.C. Circuit reversed the denial of a habeas petition and remanded the case that led to a release. And the D.C. Circuit made clear in a decision called Kiemba last year that in its view, the court has no authority to order the release of a Guantanamo detainee when there is found to be no basis for detention, no evidence he presents a danger to the United States, but yet where no other country is willing to accept him. Now, Judge Silberman, a senior judge on the D.C. Circuit, appears, like many of the D.C. Circuit judges, to have been quite unhappy with the Supreme Court's Boumediene decision, and recently said if the president is not going to even release habeas petitioners when the court does find that they should not be detained, then, quote, the whole process leads to virtual advisory opinions. It becomes a charade, a theoretical assertion of judicial supremacy sustained by posturing on the part of the Justice Department and providing litigation exercise for the detainee bar. The Guantanamo limbo state, sadly, persists. While Guantanamo is the most famous detention location, there are far more detainees, or had been up until recently, more detainees held in Bagram, the U.S. Air Force base in Afghanistan. In fact, President Obama tripled the number of detainees in 2008 of 600 to nearly 1,700 in 2011. There, prisoners are not afforded even the same rights that Guantanamo detainees are provided. And as the Obama administration has argued, continuing the Bush administration's position, detainees at Bagram are not entitled to habeas. Finally, there are reports, even in recent press, The Nation had an article last month, that secret prisons may still be continuing. On his second day of office, President Obama prohibited the CIA's future operation of any such facilities, but made clear that detention facilities did, quote, not refer to facilities used only to hold people on a short-term transitory basis. There are reports that there are such similar facilities in the Horn of Africa. Specifically, there's been a well-documented report that in Somalia, there is a center there where nominally the Somali National Security Agency operates that facility, but the United States pays salaries and directs interrogations of prisoners there. And finally, just this summer, we learned that detainees captured outside of Afghanistan, such as the Somali Ahmed Abdul Qadir Warsami, who was traveling from Somalia to Yemen, may be held on U.S. military vessels and interrogated there, in his case, for 2 months. He was eventually transferred to federal civilian court for prosecution, and elicited condemnation on both sides. On one side, individuals saying, how could you put him in the civilian justice system? He should be sent to Guantanamo. And on the left, complaints that he should never have been held in such a detention. This use of naval ships, however, harkens back to what were known as ghost ships in the early years of the Bush administration's response to 9/11, where numerous ships were reportedly holding individuals to avoid the reach of the International Committee of the Red Cross and other oversight. So how did we get here? How was this detention operation created? Well, certainly the issues are difficult and complex. As General Gill indicated, we need to be prepared, and perhaps we weren't at that time. Just as one example, at the time of the 9/11 attacks, there were only, I believe, 500 interrogators in the U.S. Army. Of that group, only 108 spoke Arabic, and of that group, perhaps a handful spoke Pashtun and Urdu, critical languages, if you're going to interrogate individuals and make decisions about detention. Consequently, what occurred? Individuals were paid to translate, and those individuals often harbored grudges, as had been documented. They had an incentive to find that these individuals should, in fact, be dangerous Al-Qaeda or Taliban. And of course, in some cases, partly due to language difficulties, detainees were transferred to other countries for purposes of interrogation, where it was quite well known they would be tortured. But the other reason I would submit that the detention operations exist as they do now were due to some of the extreme positions that the Bush administration advanced immediately after 9/11, arrogating to itself enormous powers due to claims of military necessity, relying solely on Article 2, arguing that to wage a global war on terror, we needed a new paradigm, a focus on prevention, a 1% doctrine, if you will, to work on the dark side. International law was entirely disparaged, and the criminal justice system was often viewed as useless or too reactive. Ignoring many of the military's advice and counsel, ignoring Secretary of State Colin Powell, President Bush determined that the Geneva Conventions did not apply to Al-Qaeda, and that common Article 3, which lays out the minimum humane requirements and various basic attributes of a fair trial, did not apply to either Al-Qaeda or Taliban detainees. In court, the United States Deputy Solicitor General argued concerning the fate of detainees at Guantanamo that the United States could detain them indefinitely, without any compliance with any rule of law of any kind, without permitting counsel, without acknowledging any judicial forum in which its actions may be challenged. Even if, this was in 2003, the claims were that the United States was engaging in acts of torture or that it was summarily executing the detainees. As the Ninth Circuit observed in Garebi versus Bush, the United States government has never before asserted such a grave and startling position. Now, with the Obama administration, there have certainly been changes. Immediately in coming into office, the Obama administration banned the use of torture, declared that all interrogations must adhere to the Army Field Manual. They announced their intention to close Guantanamo, fidelity to international law, reliance on Congress's authorization for use of military force, as opposed to Article 2. And indeed, Obama said there was no longer a war on terror. The war was against Al-Qaeda. And yet, many things, as I've described about the current detention state, persist and continue. Why? Well, a couple of the reasons are the same as I laid out perhaps for why the Bush administration embarked on this trip. The issues still remain complex. And certainly the Obama administration inherited a system that it is not easy to extricate itself from and to extricate this country from. Some would say the movement really, to the extent there was any change already in policies, and there has been some, actually preceded Obama. And so perhaps he isn't even deserving of credit of some of the changes. There were public disclosures about torture, innocent detainees in secret detentions, thanks to whistleblowers and the press. And certainly the Supreme Court's decisions in Rasool and Hamdi in 2004, and Hamdan in 2006, and Boumediene in 2008, did lead to some changes by the Bush administration. Indeed, President Bush spoke of his intention to close Guantanamo. He acknowledged the use of enhanced interrogation techniques and announced the closure of secret detention programs. Greater legal rights were afforded detainees at Guantanamo. And the Defense Department changed its policy. Common Article 3 would apply to detainees in military custody. And Congress passed the Military Commissions Act. So in some sense, checks and balances had worked in their own way, and some changes had already been effected. But there's, of course, another view. The court decisions didn't make such an impact. While there were markers of institutional significance that the court and Congress had a role to play, these decisions did not speak really to what is the content of the rights of the detainees. Terrorist suspects, it was unclear what, in fact, rights they may have, particularly non-citizens held outside of the United States. And the Obama administration has not done much to fill that void. Now, why else, perhaps, has there not been as much change as might be expected by the Obama administration? Well, certainly politics are one explanation. Efforts to close Guantanamo were stymied by Congress in placing restrictions on those efforts. Announcements or intentions to try suspects, including Khalid Sheikh Mohammed in the Southern District of New York or anywhere in the United States, were similarly prevented by Congress. And why else, perhaps, have things stayed the same? Well, it's what I call he's the president stupid principle. It should not be a surprise entirely that President Obama, rather than candidate Obama, has taken a different view toward executive power. He has undoubtedly seen certain intelligence that none of us, perhaps have been, with a few exceptions here, have probably been granted the right to see. But by and large, he fits, one may argue, within the historic tendency of presidents to assert significant powers at times of national security threats. So just another accident or incident of the dustbin of history. But I think anchoring President Obama's support and defense of many of these detention policies within a historical pattern is cold comfort. 10 years after 9/11, the detention state has questionable legal footing. And neither the president nor the other branches have acted sufficiently to alleviate that confusion. The current administration relies upon the authorization of use of military force as the basis for all of its detention practices. But critics have questioned how sustainable the reliance on the AUMF can be. It's a resolution passed by Congress 1 week after the attacks, authorizing force against those responsible for the 9/11 attacks, namely Al-Qaeda and the Taliban. In 2004, the Supreme Court in Hamdi upheld detention based upon the AUMF. The court rested its holding in part on the fact that U.S. military forces were still involved in combat activities in Afghanistan. But the court warned, if the practical circumstances of a given conflict are entirely unlike those of the conflicts that inform the development of the law of war, that understanding may unravel. It is safe to say that the war on terror is distinct from conflicts such as World War II. It appears to be a war without end in time or place. 10 years out, the president has authorized indefinite detention. Al-Qaeda is largely decimated. Suspects are detained from regions as disparate as Yemen and Somalia. Authority is claimed to detain those with highly questionable connections to Al-Qaeda, and the U.S. is readying to exit Afghanistan. I believe we're beginning to see the unraveling of the court's understanding of the basis for the detention state. The AUMF is and will be stretched too far as a credible basis for detention, leaving many questions as to what can lawfully support the U.S. detention system. The President, Congress, and the courts must rectify this, bringing precise clarity to who may be detained and on what legal basis. But the confused state of detention is unsupportable.
Pinned in there. Well, first of all, I would like to once again echo the thanks for the organizers of this event and to all of you for coming to here and anyone who's listening to us on webcast. As we've been thinking about the 10 years after 9/11, and seeing once again the images on our television screens from that day, something that really struck me as someone who works in military ethics and who, as you heard, for 11 years taught leadership ethics and law at the U.S. Naval Academy to future Navy Marine Corps officers, is the image of, on that day when the towers fell, and those gray plumes of smoke and debris blossomed out from the fallen buildings. And you saw so many people covered with that gray and that big gray cloud. And I can't help thinking that that is what happened to all of us, because the gray descended, and the clarity that we might have had prior and some of the understanding we had of the lines, where the bright lines were, where the black and white was, got lost in that gray cloud. Since I work in military ethics, I am concerned both with why we take nations to war and how we conduct those wars. Fancy terms, we call that jus ad bellum and jus in bello. And both those areas were profoundly affected by what happened on 9/11 and what happened since. To give just a couple examples, if you look at the jus ad bellum side, why we take a nation to war, the conflict with Iraq, the war with Iraq, raised a lot of questions about traditional just war theory. Traditional just war theory does not permit preventive war. Now the question has been raised, was the war with Iraq preventive or preemptive? And scholars have debated this. I won't give you a lengthy dissertation on the subject, but I will say that by my understanding of the just war tradition, it does not pass as a preemptive war. Preemptive war is very narrowly defined in the tradition and requires essentially the ships are on their way to attack you, the enemy is gathered at the border, an attack is imminent and immediate. It does not allow for preventive war where you anticipate that at some point the enemy may attack and that he is building arms for attack. If you do agree with me, and feel free not to, that's why we're here, but if you happen to agree with that assessment that the Iraq war had more of a preventive than a preemptive basis, then that means that when we chose to enter into that conflict, we shook part of the foundation of the tradition that goes all the way back to the Greeks and Romans of the just war tradition. Now, the other conflict that we associate obviously very directly with 9/11 is the conflict in Afghanistan. Now, it's less ambiguous in the sense that we see we were attacked and we responded and we were wiping out some of the bases and the training strongholds and the people who were immediately supporting those in Al-Qaeda who had attacked us on that day. And of course, this has later been borne out in discovering the whereabouts of many of the leaders, although, as we all know, we found bin Laden ultimately in Pakistan and not in Afghanistan. He had fled to Pakistan. Now, the issue with the Afghanistan war is less one of preemption and prevention, and rather the question of, is it ever appropriate to attack a state because of the non-state actors contained therein? And how do you classify a state as being sufficiently failed or sufficiently rogue that it is appropriate to ignore its sovereignty and attack those within it without their permission? And of course, this issue now grows even more gray and more interesting as we deal with the modern technology available to us, like the drone attacks that are possible, that allow us to attack within sovereign nations without necessarily asking permission or sending in any troops that could be blocked by the forces of that nation. So just on the side of jus ad bellum, on taking a nation to war, in both Afghanistan and Iraq, we have some serious questions raised about how this affects the tradition that we have had for so many centuries. Now, on the conduct of war side, here too, and we've heard some references in a sense to this, here too the gray cloud has descended. In fighting those who are not only non-state actors, but definitely committed to harming civilians, to intentionally putting civilians in harm's way and to intentionally targeting civilians. The traditional laws of jus in bello are challenged in a meaningful way. And I have to say, and I presume that this might be somewhat biased because of the job that I held, but I think in large measure our troops have done an incredible job navigating the complexity of that, of fighting non-state actors within particularly urban environments where our enemy is not uniformed and we are trying to determine who is the one that deserves to be viewed as a combatant and who should be given protection. Having said that, of course, as in any conflict, some mistakes have been made. And I think that some of those mistakes may have been driven not only by the complexity of urban combat, but again by the complexity and confusion that arises with not having traditional warfare and not having a traditional enemy. And having also, I think, a sense that the people that we are fighting against have no rules. When I spoke to my midshipmen at the Naval Academy, one of the things we had to really wrestle with is, why should you obey any rules? Why should you keep certain standards and keep certain codes up if your enemy not only is thwarting those codes, but is actually going to use your code against you, is going to use the fact that you might try to protect civilians as a way to sneak suicide bombers closer to you, for example? How ought you to respond to that? Are you supposed to just take it and say, well, all right, so more of us will die, but we won't change our values at all? Or is there some third position? And trying to wrestle with where, if there is a third position, what is it and what does it look like, is something very far down in the weeds and something that our troops have had to deal with, and thankfully in some cases have gotten some guidance from military lawyers, as we've heard, but perhaps not always clear and consistent guidance, and not always the degree of guidance that they need to deal with these complex situations. The other area that has again been referenced here today is the question of torture and related issues like extraordinary rendition. All of that is wrapped up in this question again of who is the enemy and should we treat this enemy differently than other enemies. And I am fearful that since 9/11, because of the fear and the horror of that day, that we have fallen a little too far from our previous principles of how we should treat enemies. I would rather see us hold to the long time tested military ideals of how to treat the enemy and how to treat prisoners of war, and perhaps err on the side of giving some of our enemies more than their conduct deserves, than to go the other direction and to provide them with less protection on the grounds that they are a different kind of enemy than in the past. If they are so far a different kind of enemy that we cannot interpret how to deal with them with the old language, then I start to question, should this even be a military operation? If we don't know how to treat them, whether like criminals or like enemy soldiers, then maybe it should be treated, they should be treated like criminals, and criminal law should apply. But insofar as we are trying to treat them as both at once, again, we put our troops in a very unfair position, causing them to toggle between being policemen and police officers and being warriors. And I feel that is not fair and too much for us to ask. I did not, thankfully, personally lose anyone on 9/11, but I did lose 4 very dear friends in the conflicts that followed. And reflecting on their loss and their deaths makes me again want to, as part of this panel discussion, ask us, what have we done in potentially undermining the principles that they fought for and the principles that they believed in? I don't mean to be excessively on my soapbox here, but it concerns me greatly when people who are in the political arena or people who are in my job or other jobs very far from the combat front lines are making judgments about undermining principles of war, using as their argument, we are doing this to protect our troops or to support our troops. Because those very troops have already made the commitment to risk their lives, to lay down their lives for those principles. You're not doing them a favor by undermining the principles that they signed up to fight for. So insofar as you look at issues like torture, it was not our military driving and pushing and saying, we want torture. It was not people like Senator John McCain, who has been tortured, saying, this is a great idea, let's do this. It was people outside of that circle who were pressing for these tactics and saying they were doing it for our troops and for the protection of our troops. And I think as time has gone on, we have seen more on the other side of the equation that, in fact, when we are true to our principles, it allows for greater safety in the end for our troops with the counter-insurgency tactics that provide for trying to win over the hearts and minds of civilians. That requires us to be consistent in our values and to be trustworthy in what we do. I'm not going to take time here at this podium to tell you all about all of the friends that I lost, but I do want to mention two of them, of the four. One, a Marine who was killed on June 25th, 2003 in Al-Hala, Iraq. Before he died, he wrote to me a great deal, and one of the things he said was that he had some concerns about why we went to war in Iraq. But he felt some of those concerns could be overcome if we fought it the right way and for the right reasons. So he is an example of someone who was saying, pleading in a way, with those in leadership positions, if you send me here, if you put me in this job, make sure that you don't put me in a position of undermining what I believe in and what I fight for. So I feel an obligation to him. The other person is an even more tragic story. Every death is tragic, but this one was a suicide. One of my colleagues from West Point committed suicide in Iraq, and in his suicide letter, which was addressed to General Petraeus, he stated that the reason he killed himself was that he could not bear any further dishonor. And the dishonor that he had experienced that had driven him to this point had to do with working with private military contractors in Iraq, and his feeling that they were not upholding the very values that he had so faithfully taught at West Point. So my lasting impression of what has happened in the past 10 years is that we have gotten lost in that gray cloud, and we need to find our way back for our own sakes and for the sakes of those who are put in harm's way by what happened. And insofar as we can return to the basic principles, I'm afraid, I know the historian part of me is driving this, but I'm afraid there's nothing new under the sun. We are not the first nation to deal with terrorists by a long shot, and the rules of the past had a lot of thought and care behind them, and I would like to see the just war tradition returned to and restored and lived out in our laws. Thank you.
I asked the general how long he's going to be here because I teach at this school, and I could sense when my audience wants to ask questions. That's just how the students are, and I feel there are a lot of questions out in this audience. And I want you to have the ability to question the general on basis of his comments and the other two folks who are about to follow, myself and Justin Herdman. Let me just add one additional disclaimer. Justin and I are both under security clearances, so regrettably, we can't talk about certain things, otherwise we'd be committing a felony. And that includes facts that are basic to the folks we represent in Guantanamo. When we sign on to represent someone in Guantanamo Bay, we have to sign a memorandum of understanding that imposes upon all the lawyers basically a cloak of secrecy, whether you're secret or top secret. Top secret's basically for high-value detainees. As a consequence, weirdly, we can't look at WikiLeaks, and we've been so admonished because WikiLeaks contain materials that are incorporated by the Memorandum of Understanding. So your First Amendment rights right now, ladies and gentlemen, so long as you haven't signed the Memorandum of Understanding, are actually broader than my own. As I sit here, I'm telling you That warning, by the way, is posted prominently in the secured facility in Crystal City, Virginia, where all the secret documents are kept. So when, for example, I have to file something in Guantanamo Bay detainee case, which is in the District of Columbia, the district court there, I have to travel to Crystal City, Virginia. Everyone does, the prosecutors too, and in fact, I can't take notes in with me because if I do, they have to stay there under seal. And I can't show them to my client because that's top secret too, just to give you an idea of some of the complications that go along with Guantanamo Bay litigation. I brought a couple of examples to sharpen the points that have been made, and we didn't arrange ourselves the way we're seated here, but I couldn't imagine a better arrangement because the last comments by Professor French talking about having faith in our traditions and our principles, I think I could not underscore more had I had a yellow highlighter on a PowerPoint. Let me give you an example of how we've kind of got off track too from this purely litigation front. I'm holding here a 162-page document. This is from the District of Columbia's District Court. It is a docket, electronic docket printed out for this purpose, just to show you this is just the parties and their lawyers in one case. Now, mind you, there are a number of parties here that are last name unknown petitioners, uncertain who's doing what for whom. But in one instance, there are actually multiple pages of lawyers who have come and gone. I'll say both for the defense and the prosecution. This is litigation run amok, everyone. All of these proceedings are under the CIPA Act, which is Classified Information Procedure Act, which means that even the public doesn't see most of this because it's protected. That's fair enough for the people who are litigating, but to give you an idea of the practical problems that presents, when we go into district court in District of Columbia, all our cell phones come out of our pocket. We turn them over to the marshal. Court reporters under a security clearance. No one comes into the courtroom except the lawyers, the court reporter, the judge, and the law clerk. Nothing gets transcribed that's not confidential. The transcription of the proceedings are, of course, then in the secured facility, which means you have to go to the Crystal City facility to look at those. And on top of that, the public learns only a bit pieces. If you go to one of the other dockets I brought here too, 107, or this one's only 74 pages. This is just the proceedings themselves. I counted over 200 entries here. The vast majority, take my word for it, are not for your eyes, even though it's a public document, because they're protected by CIPA, Classified Information Procedure Act. Causes a real burden for litigation. I'm going to throw out another challenge to y'all. This is a big point of dispute in our litigation. Why aren't we just trying these cases in our Article III courts? The comment that was made by a number of people that the district judges are frustrated is an immense understatement. I can't reveal to you all that went on in a transcribed conversation, but let me just leave it at this. You could grant habeas after you go through a massive hearing at which the defendant detainee is not present because Congress decided not to give any money to transfer anyone out of Gitmo, which means they appear by video conferencing. So you have all these witnesses by video conferencing. The judge has his or her law clerks meticulously work on the case and issues this long opinion, which you don't see, of course, because it's protected under the Classified Information Procedure Act. At the end of the day, the State Department or the Department of Defense or the Department of Justice or the executive branch president himself or the White House comes in and says, sorry, no country wants this person. When the president of France met with President Obama, he agreed to take one detainee. There are 171, that's numbers right. There were currently, as of May, there are 171 detainees. Many of them don't want to be there, obviously. Some are protests. Some don't want to see their lawyers. I'll tell you that right now. We go down there. They go trail them all the way down to Gitmo. They say, sorry, we don't want to visit today. Visits are randomly canceled. We had 2 visits next week canceled for reasons because the Red Cross is coming to visit, so we can't get on the base. But the fact of the matter is they could get habeas relief and they're not going to be released anyway. I'll throw this challenge out to y'all. The 2 days after President Obama took his oath, he issued important executive orders on the topic of Gitmo. He put together a joint task force. General, I couldn't agree with you more. this is an area where we need joint task force efforts in an immense way. 1 year later, on January 22nd, this is public, by the way. You could go see this on the Department of Justice, or if you just Google the final report, it's called From Guantanamo Bay Task Force Review. In it, they reviewed every person who's detained in Guantanamo at the president's executive order. That night, by the way, when that order went out, I was helping draft a letter that was going to be circulated to the defense lawyers around the country and ultimately delivered to the president saying, Mr. President, congratulations on your inauguration, and we're grateful that you're taking this step, but you forgot to include the defense lawyers in your review. So true. No private defense lawyers were part of that review. Nonetheless, here are the conclusions that they reached in that report. And I throw this out because it strikes me as this is a very good starting point, even though we are almost 2 years later. They then examined 240 detainees. They said 126 were already at that point approved for transfer. Now we could do the math. 240 minus 126 shouldn't mean there are 171 detainees still there. Quite a few less. More importantly, they said 44 are ready to be referred to prosecution for federal court or military commissions. So take away another 44. Take away another 48, which they conclude were determined to be too dangerous to transfer, but not feasible for prosecution. Now let me repeat that. Too dangerous for transfer, but not feasible for prosecution. The conclusion was that they don't have enough evidence on these people to detain them. Something's wrong with a system that's based on evidence when we don't have enough evidence to detain or prosecute. And finally, then they had 30 Yemeni detainees, which are a problem because of the status of Yemen, and the president said no one gets transferred back to Yemen. The fact of the matter is, at the end of the day, we should have fewer than 100, way fewer than 100 detainees in Guantanamo. We don't. We're not doing our job. As lawyers, we're not doing our job. And frankly, the system is not doing its job. This problem has been stalled by Congress. The general's right, professors are right. In 2010, the Congress decided to defund all transfers out of Guantanamo. My suspicion is, though, that if there was a reasonable proposal put forward to quickly resolve this issue, we would be further ahead than we are right now. It was May 2009, I did not misspeak, 2009 that Congress defunded any transfers out of Gitmo. So shortly after the president decided to take some action on this problem, Congress took away his funding. I'll leave this with this one picture, and for those who are traveling back through the airport or through our airport at Cleveland Hopkins, as we all know, the searing images of 2011, September 11th, were all in front of our TV screens and our eyes this weekend. Go to Hopkins Airport, one airport of all the major cities in the United States, and there's this huge board. I always get puzzled by it, right by TSA, of all the stuff that got through or caught. It includes hand grenades, guns, bullets, batons. And I wonder that all of our millions and billions and trillions of dollars are really being used in a wise way. Literally, while I was driving here today for this presentation, a professor from another college down south was interviewed on the radio. It was just headline news. He estimated that since September 11th, the Department of Homeland Security has been allocated and has spent $1 trillion. I am one of those who does not want to see those gray plumes of smoke over my country ever again. I almost lost a brother in 9/11. His building collapsed. He worked at World Trade Center 7. He got out. But as an American, and as a person who has huge confidence in our Constitution, after all, I'm the one person sitting here whose job is defined in the Constitution, the Sixth Amendment. I want us to put faith in those institutions and finally say, are we using our head wisely when we spend that $1 trillion to make us all safe? Thank you.
I did want to thank Dennis for letting me go last. That's usually the way we do this. Prosecutors go after defense attorneys. So I thought he might try to switch it up there. And also, Professor Strassfeld said, nothing I can say can get me in trouble. I'm not quite sure how true that is, but we'll have to talk about that gift bag after I'm done talking here. Might run afoul of some Justice Department regulations. I did want to start off just, and I do want to be brief. I know everyone has said that. I really do want to be brief. But from a personal perspective, I was actually in Lower Manhattan on September 11th. I started work at the Manhattan District Attorney's Office on September 4th, 2001. So I'd been a New Yorker for all of a week on the day that the towers came down. And what I can tell you about that day, I could tell you quite a bit about it, but I remember a couple things in particular. One was that on the subway ride down to City Hall subway stop, which is where I got off, I was reading an older newspaper. I was, after all, working at the DA's office, so I had to take my reading material where I could find it. So I was reading, I think it was about a week-old newspaper. It was a front-page New York Times article about the noise pollution in New York and how this was going to be a major issue in the mayoral race that year. How this was the new wave of law enforcement efforts were going to be directed at noise pollution and reducing noise pollution. And at the time I thought, yeah, that kind of makes sense to me. I better read up on this because this is the kind of thing I'm going to be focusing on, at least my first year at the DA's office, cutting down on noise. Well, it turns out when I got off the subway, there had already been a very loud noise, which was the first plane going into the World Trade Center. I did not hear it. I was on the subway. In fact, I probably heard firefighters responding to it, and I just didn't even notice because I figured, well, that's kind of what happens in New York. There's sirens, there's loud noises. So I did quickly find out thereafter what had happened, and I was close enough that I could see more than I ever wanted to. But what I can tell you is that when I left that day, we were told to leave. We weren't really given much choice in the matter, but it was after both towers had come down. And I was walking out of Lower Manhattan. There were people that walked next to me that were covered in dust, head to toe. I was not one of them, fortunately. But as I was walking out, I thought, what do I do now? Where do I go? I just got kicked out of my job, told to leave. And so the next morning, September 12th, I woke up and I went to work. I got somehow south of Canal Street, got to the office, and I'll never forget this. There was a court security officer standing in front of the building there, and he looks up at me and he says, "What are you doing here?" And I said, I came to work. I figured there's something that has to be done. You know, maybe somebody got arrested. I'll help draw up the complaint or something." He said, "Do you have any idea what happened yesterday?" And I said, "Yeah, I have a pretty good idea what happened yesterday." He said, "Go home." So I went home. Somebody in uniform told me to go home, so I went home. And I remember being left with this overwhelming sense of what do I do? Why can't I contribute at this point in time? And I have been very fortunate in my career that I know now if that happens again that I don't have to ask that question of myself. And the point that I'm trying to make here is that there were a lot of people that were in my position on September 12, 2001. A lot of people in the New York City Police Department, a lot of people in the federal government who were asking themselves, what do I do now? How do I contribute? How do I make a difference? And 10 years later, the one thing that I know personally and that I also see from an institutional perspective is that question doesn't get asked very often anymore. We are much better prepared today to deal with an attack, maybe not necessarily the magnitude of 9/11, but pretty close, maybe even bigger than 9/11. We won't know, and hopefully that never happens, but we won't know until it happens how prepared we are. But what I can say is that across federal government, across state government, across local government, there are many people who do not have to ask themselves that question the next time something like this happens, if it happens. So that's the one, looking back over the past 10 years, the one thing that I can say on a personal and again on a professional level is preparedness. And I do think that we are much better prepared today, certainly than we were on September 11th, but even in the years following, I think that we are much better prepared. For instance, our office, as do most federal agencies, engage in a continuity of operations planning. We engage in planning for critical incident response. We have exercises. We have interagency exercises to touch upon what General Beck was hitting at there. The second thing I wanted to point out was if you had asked me on September 12, 2001, if you had asked me when is the next attack going to happen, I would have said, it's going to be soon. It's going to be next month. It's going to be 2 months from now. And if you'd told me that there would not be a successful terrorist attack in the United States in 10 years, I certainly would not have believed you. It just simply would not have believed you. And the fact that our preventative efforts have resulted in no acts of international terrorism, depending on how you define it, but certainly no successful attacks, again, depending on how you define it. We have been very, very successful, I think probably more successful than anyone would have anticipated 10 years ago, 5 years ago, even 3 years ago. That's not to say that we haven't been lucky. We have. But we have ultimately, our prevention efforts have paid off. And what I do as a prosecutor is a small part of that. It is one tool in the counterterrorism toolbox. And from my perspective, as somebody who has been involved in terrorism trials and cases that have been prosecuted in an Article III court, I can tell you that at least that tool, it really does work. It works in terms of getting a case to a jury. You get 12 people to agree on anything in this room, 12 people. What's the fastest way to get to Brown Stadium from here? Try to get 12 people to agree on that. It's not very easy. But if you get 12 people sitting in a room together deliberating on someone's fate, it's a very serious issue. And we have been able to do that successfully across the country in every district almost, successfully test terrorism cases in front of 12 jurors. In some cases, those have resulted in acquittals, defeats for the government. In some cases, they've resulted in multiple mistrials. And in some cases, they've resulted in convictions. And when we've had convictions, judges they have a lot of discretion now in terms of fashioning a sentence in many instances. So that's not the end of it, it's just getting a conviction. There's also sentencing that comes into play as well. And in some ways, I think, standing here as a prosecutor, I have a luxury, which is I have certain guideposts. I don't have to sit and determine what is the status of international law on this issue. I have a statute, I have a case, I have ultimately the Constitution to guide me. And so in that sense, I am aware of the fact that that is a luxury that I have. So those are kind of the main points that I wanted to make. But ultimately, I think it boils down to two things when I look back on the past 10 years. We are much better prepared today, and our prevention efforts, although we have come short in some senses, we could have done a better job in other areas. We've made some mistakes. Ultimately prevented another 9/11 from happening or anything even close to that magnitude. And I think that at the end of 10 years, that, looking back, is a success story. Thank you. I'll leave it, and I think we have about 15 minutes for questions now.
We do have about 15 minutes for questions, and please come down to the microphones. We are being webcast, so it won't work if you don't come down to the microphones. I have questions if nobody else does, and I will take the moderator's prerogative, but I assume somewhere amongst you?
Thank you, everybody. Is this all right? Thank you, everybody, for all your comments and for coming today. I just want to ask like a real basic question, and then get anybody can take it. But I wonder if there's an impression around the world that a lot of what we're reaping right now and what we're hoping we learned after 10 years is a response to just a U.S. imperialism, a sort of empire building through business. And why do they hate us so much is a question. Why did 9/11 happen in the first place? And I see us all trying to balance, the security as opposed to the invasion of our rights, and especially anybody who loves the law, I think, hates how quickly we abandon our core principles after getting poked in the eye. And it's easy to have character when things are going your way. Character is proven when you're swimming upstream. So anyway, again, very basically, 10 years later, how did we get here? And what kind of policy directives do we have to change so that we are perceived as that shining city on a hill that we enjoyed and that we really felt a nationalism and a pride, to now kids travel overseas in high school, they say, tell them you're from Canada. Anyway, I hope you get the gist of my question. That's just a human being asking a question about the law.
No, just scoot the, yeah.
All right. Thank you for that question. It's a great question. A great question. And it comes to, I mean, it's a natural question. And the thing that immediately came to my mind was Secretary of State Colin Powell's response when he was asked a similar question about America. And he responded that America, after World War II, that all we asked of France was enough ground to bury our dead. And so there can be different views. I take a view and believe it with all my heart that America is not about empire building. America is not about aggrandizing ourselves at the expense of the world, but that we still stand for all of those great principles. And I am very, very proud to be American and for what we're doing throughout our federal government, throughout our military. So, but it's a great question, and I'm sure there may be different, there may be other views with regard to that. But there's another lead-in that I'd like to take your question and to address it further. And first of all, I will refer to the remarks of the Federal Public Defender. You talked about that you and the Assistant United States Attorney were not able to speak about certain subjects. I worked in the Department of Defense General Counsel's office, worked on TSSCI, signed a confidentiality agreement that said, for 99 years I will not disclose this, and if it's still protected, I will not disclose it. And my wife said, well, you're going to tell me, aren't you? And I said, you'll be the first one I tell in 99 years. But I did want to say, and we have never met before, but I can say from my experience in the U.S. Attorney's Office in Greensboro that you know, part of our legal tradition and part of what makes us great as a legal profession is our ability to disagree. And that we can disagree on views, on difficult issues. Your question, there may be other views, we can disagree, but that we respect the other side. So when you were speaking, the image that came to my mind was John Adams in representing the British soldiers after the Boston Massacre, which must have been a very difficult thing at that point. No one would ask us to agree with the soldiers who killed Americans at the Boston Massacre, but we all respect what John Adams did, and we respect what those federal public defenders and others are doing with regard to protecting individuals, whether at Guantanamo or elsewhere, in the finest traditions of our legal profession. So I would like for everyone to join in a round of applause, if they would not, for just as a reflection.
Now I have to respond. The day Boumediene was handed down, which was on June 12, 2008, it's a very long opinion. I have it here. It's some 150 pages because, as you can imagine, it was a 5-4 split. I called in a talk radio show because I was on my way to Toledo because Justin's office was prosecuting one of our clients and the jury was still out. And I was traveling to Toledo and called in the talk radio show, which was now headline news, that the Supreme Court has decided 5-4 that the detainees in Guantanamo are entitled to counsel. And I called in and never identified myself, of course, and say, you know, I think that's a great idea. Article 3 is an important thing. Our federal courts are strong in this country. And more importantly, it's forced us to put our money where our mouth is in support of the Article 3 Constitution. The host vehemently disagreed. He said the judges will be paid off, and it's a corrupt system anyway. And every caller afterwards called me commie pinko or something like that. So there you have it. There you have it. If I could address the gentleman's question just a bit, there's another couple of set of stats that I think we as Americans need to take notice of since September 11th, 2001. I wish these were discussed more over this past weekend. we have slipped from number 1 to something like number 20 in the number of people who get college degrees in this country. Local school districts have cut out language programs left and right, so much so that when we go down to Guantanamo, we have to pay an interpreter from the foreign country because there are no Americans who know Pashto, and that person gets thousands of dollars a day that you and I pay for. In addition, I don't know about you, but I would bet a lot of money that the Arabic classes at Case Western Reserve University or the University of Akron or Ohio State University aren't very full. And the sad thing is, if we did a poll and I asked you, 10 years later, have you bothered to pick up the Quran, which is the holy book of about only 1/5 of the world's population, some 1.2 billion people, my bet is less than 50% of this very sophisticated, educated group would say yes. So my challenge to the Americans is, it is an exceptional country. Let's earn it. Let's work at it. We did before, we can again.
This question is primarily for General Beck. I was looking at your article where you talked about restoring law in Iraq, and I'm just curious to see what challenges that you face. It looks like that they're excited to get back in a position where they can restore law, but do they have a difficulty understanding how we're doing things here in this country?
It's a great question, and thank you for reading the article. My mother read it, and my wife read it, but I think that's it. But it's a great question, and this underscores what we're about in the legal profession, because I really did not have an appreciation of what the world was like if we do not have a legal system undergirding our society. I was in the office of the Chief Judge of the Central Criminal Court of Iraq, and a lady came in. She had the traditional Arabic headgear. She was crying and crying and crying and crying. And I said, please, talk with this lady. And he did, and she just kept crying and crying and crying. And what she explained to him was that in one particular province, and this was in 2005, where parts of Iraq were basically very lawless parts, that what had happened in this particular area, that her husband's arms had been cut off, his legs had been cut off, and they'd been posted at various places throughout the neighborhood as an example to the police, as an example to the judges, an example to the attorneys, do not enforce the law, because this will be what happened to you. And in the face of that, the Iraqi court, the Iraqi judges, the Iraqi prosecutor, or the Iraqi Defense Council, they took those cases and they prosecuted them at great risk to themselves and to their families. And it's part, as I would say, of what is great about our legal profession worldwide in terms of a commitment to justice, even when there is a threat to individuals. One of the things that we, the Department of State, the Department of Justice in large part, the Department of Army only in a supporting role, did was help establish a federal court system to support the provincial court system. So the provincial court systems in that particular area were not working because of the intimidation. The Central Criminal Court played the role as a federal system where individuals could be brought and justice administered in a way that people were held accountable for their actions. But the lesson I came away with was that our legal profession plays an absolute central role underscoring our society and imposing that order that we need going forward. What we did is we tried to learn from the lessons of the past in not taking our system. We didn't try to take our federal criminal code and import it into the Iraqi system, but rather took the Iraqi code and the Iraqi procedures that predated Saddam Hussein and used and helped the Iraqi judges, not us prosecuting, Iraqi prosecutors, Iraqi Defense Council, Iraqi judges, and our role was to enable and to build capacity as we go forward. And I hope that answers your question. But it's a great question, and I will have to say that I have an image of Cleveland Airport, and that image is me boarding a plane. And so I hope the discussion will continue, but it has been a true pleasure to be here, but I will have to run. And thank you very much.
Thank you. Please.
A number of the a number of the speakers referred to the difficulty with the existing paradigms of how to deal with enemy combatants, non-state actors, etc. It made me wonder, is there any effort, or can you recommend how there could be an effort toward redefining the paradigms, to trying to not shoehorn what the models of war and combat from all the past centuries to try to fit what's actually going on now? And I wondered if any of you had comments on that.
Sounds like me. That one sounds like thrown over to me. Well, I understand the concern about trying to force things to fit into the old paradigms where they can't. But as you probably gathered from my remarks, I think there's quite a lot in the old paradigms that do apply. We just have to work at it a little bit harder. And I'm somewhat reluctant to suggest that we need an entirely new paradigm, because I actually do fear that going down that path is what leads us to abandoning or corrupting some of the principles of the past. So for example, when you talk about the non-state actors, I would want to first say, well, is that what we need to pin our hats on when we're trying to understand combatant versus non-combatant status? Those who work in military ethics primarily ground combatant versus non-combatant status in threateningness. And it has to do with, I mean, for example, to use a crude example, if someone is a civilian one moment in the context of a firefight, and then they see a fallen weapon and they pick it up and start firing, in that moment they become a combatant. The opposite is also true in the sense that if someone is a combatant and then becomes so wounded that they can no longer fight or surrenders voluntarily, they are now in a protected class. So we have already this demand for great agility in the context of combat between I can fight against this person and I can't. Those are the rules that I think are the most useful in this kind of modern combat, to say who can I target and who can I not. And that, to me, that in combat assessment is the more important piece. If we start putting people in a wholly different class and it not being grounded in whether they are a threat in that moment or not, then I do think it muddies the water again in a somewhat dangerous way. So if you say, well, this person isn't firing at me, but they're a terrorist, or they're wounded and on the ground, but they're a non-state actor, that worries me a great deal. I want to say that shouldn't be relevant. So I guess this makes me sound rather traditional and stuck in a paradigm, but I feel like the paradigm has the right principles in it at that level, more at the conduct of war level. Now, if international law wants to continue as it should do, to better clarify how things like the conventions, the Geneva Conventions, et cetera, should be re-understood, that would be very helpful for those of us working on the ethics side to have some more clarity and matching between the ethics and the law. But for the ethics of it, it comes down to threat, and that is not relevant whether you're a non-state actor or not. So, anyone else want to weigh in?
Yeah. Regrettably, it's after 6 o'clock, so maybe now is as good a time as any to thank the panelists again.